Good afternoon, and thank you for joining us today. We hope as you listen remotely that you and your families are healthy. Thanks for joining Jennifer Schaus and Associates as we come to you live from downtown Washington, D.C. today in our COVID contracting webinar series. Our webinar series was created in response to the COVID-19 virus and the impact of federal contractors. We've created a COVID contracting section of our website, which has contracting resources and all of the related webinars for download. On that note, today's slides will be available on slideshare.net. As we mentioned, the webinar will be on our website under the COVID section and will also be on our YouTube channel with over 350 complimentary federal contracting webinars. A short note about us: we help federal contractors with the tactical and strategic pieces of winning business. This ranges from GSA schedules, proposal writing, market and business development, and business development. Find more about us on our website. And please join us on Tuesday, June 23rd for a virtual Hot Topics in Government Contracting virtual conference. Now, this is a remote conference, so please use the link on the screen to register. You can also visit the events section on our website to register. During this conference, we will take your live questions. The PowerPoint and webinar will only be available to those who register for the conference. We hope to see you there. And here's how this is going to work today. We will first share some helpful government websites that may be referenced in today's session. Again, our slides are available on slideshare.net if you want to access the links. I will then introduce our speakers who will give a short presentation and answer questions. We will not take live questions, so please contact them directly. On this slide is the SBA loan link and FEMA's Defense Production Act. We have a complimentary webinar on our site regarding the fine print and detail. Information on this slide points to CISA. This slide shows tax relief information from the IRS. GSA has made significant changes regarding Trade Agreement Act, so please visit their site for more information. Department of Labor updates are found here. We have a webinar on our site under COVID contracting on PPP. DoD information is here. This is the big OMB memo that is referenced in most COVID contracting webinars. Our agenda is as follows, and we should wrap up by about 2 or shortly after. The recording will be available later this afternoon, so please check back on our website, again under the COVID contracting section for the link. Today, our speakers will discuss employment law considerations throughout the presentation. Our speakers today are from Wiley Law Firm. We want to thank them for putting together some great content for you all today and making the time to coordinate, plan, and implement this webinar. So we will go in alphabetical order for our speaker introduction. Up first is Tom Bromberg. He is a partner at Wiley Law Firm and has been on board there since 2002. He focuses on federal and state employment law matters. Thank you, Todd, for joining us. Our next speaker is Christine Colony, a partner at Wiley Law Firm. Christine focuses on regulatory and employment compliance issues. It's great to have you here with us today, Christine. Next up is Tracy Howard, also a partner at Wiley Law. She focuses on representing her federal contractor clients in bid protests before the GAO, the Court of Federal Claims, state courts, and government agencies. Tracy is also an adjunct professor at George Mason University's Law School. And last but not least is Posi Oshinowo, special counsel at Wiley Law. Educated at Northwestern with a law degree from the University of Alabama, Posi focuses on employment law and unfair labor practices. So that's the Wiley team, a great bunch of professionals, and we are excited to hear what you have to say about reopening America and how it affects employment law in these unprecedented times. A quick note before we begin: we are not taking live questions, so please email the speakers directly if your question is not answered today. Let's dig in.
All right, good afternoon. My name is Posi Oshinowo, and I'm very happy to be here with my colleagues to share some insights and tips about operating during the COVID-19 pandemic with all of you. We've been closely monitoring and making efforts to predict how the COVID-19 pandemic affects employers, including government contractors. And one of the most important areas in that regard is understanding how legal obligations that predated the COVID-19 pandemic, as well as those that arose during the pandemic, should affect employer conduct. I'm going to spend a few minutes providing a brief overview of those issues. So, operating during the COVID-19 pandemic implicates a number of employment law issues, but there are a few basic principles that can help employers mitigate potential liability under relevant employment laws. Of course, being aware of your obligations and analyzing which laws are implicated by certain actions is important. It's also very important to stay abreast of legal developments and guidance at the state and federal level. I think the key thing for employers at the end of the day, though, is making sure that they are consulting with relevant managers, consulting with inside and outside counsel, and making sure that they are documenting the business reasons for the decisions that they make during the COVID-19 pandemic, as a result of the COVID-19 pandemic, and documenting the basis for those decisions. One of the things that's going to be very important, and we'll talk about a little bit later, is understanding how you can mitigate liability by referencing guidance that you've received from the CDC, from state and local health agencies, and from the federal government. Next slide. In terms of what obligations employers have, there's really a patchwork of old and new laws that are the source of employer obligations. On the new side, there are federal, state, and local executive orders, which my colleague Chris Conley will speak to you about in greater detail. Employers must also, however, be aware of their obligations concerning leave under the new leave rights created under the FFCRA, as well as the obligations created by the CARES Act. That's especially important for employers who received PPP loans. There's recent guidance has been put out about those PPP loans and how employers can obtain forgiveness. Unfortunately, we don't have enough time to go into that in detail, but I'm happy to speak with anyone who has questions about how that guidance affects them off the webinar. On the old side, there are federal, state, and local laws that employers are probably quite familiar with. Those laws are still very important, and they should be on your mind as you make decisions during the pandemic. Title VII, the ADEA, the ADA, and their state and local analogs are familiar statutes that prohibit discrimination on the basis of national origin, race, sex, age, or disability, among others. And it's incredibly important for employers to be mindful of potential disparate treatment claims in relation to the decisions that they make during the pandemic. In terms of reopening or continuing operations during the pandemic, these laws can be implicated in a number of decisions. For example, who can return to the physical site and when they can return, which employees will be selected for reduced functioning. The ADEA, Title VII, and the ADA are especially important with respect to those decisions because there's so much conversation surrounding the origins of the virus and the individuals who are potentially at greater risk of experiencing severe reactions to COVID-19. It's very, very easy to make a quick decision without documenting the basis for that decision and understanding the potential impact on liability. So again, those three principles that I mentioned with the previous slide are extremely important. Also, there's OSHA, which is the Occupational Safety and Health Act, and the National Labor Relations Act. A lot of employers do not understand how OSHA and the NLRA impact their current operations or even their past operations prior to the pandemic. OSHA and the NLRA, OSHA obviously relates to workplace safety, and employers have a general duty under OSHA to ensure that the workspace is safe for employees. The NLRA, the National Labor Relations Act, regulates unionized employment and workspaces mostly, but it also regulates non-unionized workspaces and allows for employees to engage in what's called protected concerted activity that allows them to discuss and complain about the terms and conditions of their employment. Things like safety in the workplace could potentially give rise to issues under the NLRA. We'll talk about that a little bit more later on. But for now, that is all I have for you. I'm going to pass things on to my colleague, Chris. Next slide.
Thanks, Posey. As you consider reopening or more fully resuming operations, there are a variety of resources, as Posey noted, that employers should, and in some cases must, consider. On the federal level, employers should review the Centers for Disease Control and Prevention guidelines. While the CDC initially provided interim guidance for businesses and employers on how to plan and respond to COVID-19 in March, earlier this month, the CDC provided updated guidance and decision trees, including a decision tree for workplaces, to assist those seeking to resume phased business operations. We have included those sites for your convenience. The Occupational Safety and Health Administration also has created guidance for employers. Employers should review OSHA's guidance on preparing workplaces for COVID-19, which includes steps employers can take to reduce workers' risks of exposure to coronavirus. You should remember that these recommendations from the CDC and OSHA are just that. They're guidelines, they're recommendations. They are not binding on employers, but they could be cited by unions, disgruntled employees, or others as what should be best practices. Next slide, please. On the state level, each state is, either individually or in alliance with neighboring states, creating a reopening plan. These plans are frameworks that set forth various phases of reopening and the criteria for movement through the phases. As part of the reopening, but separate from the plans, governors are issuing executive orders. These orders typically supersede the prior closure orders and permit certain day-to-day business operations to begin on certain dates and under certain conditions. Employers must carefully review relevant state executive orders addressing reopening. These orders can be found on the governor's website under Executive Orders or under a tab COVID-19 Resources. Additionally, states have specific websites devoted to COVID-19, and some of these websites include the orders and the reopening plans. Many entities, including the U.S. Chamber and the Council of State Governments, as well as our own firm, have compiled listings of the orders as well. We have provided those sites for your convenience. Since it's an evolving situation, the orders are being updated through amendment or the issuance of new orders as new phases of the opening take place, or to address new sectors of the economy, or as new information or circumstances develop. It's important that you confirm you have the latest orders and ensure you are aware of the most recent requirements. Many states have also provided interpretive guidance or frequently asked questions to assist in compliance with the new orders that are useful to review. They too can usually be found on the governor's site or the state-specific COVID-19 site. It's important to note that unlike the CDC and OSHA guidelines, most of the state orders contain mandatory requirements and not simply non-binding guidelines. A violation of an executive order can lead to significant fines or the shutdown of a business, or in certain circumstances where there is substantial risk of injury to an individual, even criminal prosecution. And as you might imagine, enforcement actions typically stem from a company's failure to comply with social distancing and other related requirements in the workplace, and are often brought to the attention of regulators by an employee or a competitor complaint. Next slide, please. So which orders should you look at? For employers with locations in multiple states, each state's order must be reviewed and followed for that location. As a result, you may not be able to have a company-wide plan, but rather location-basis plans or building-basis plans. For employers who have employees commuting from other states or jurisdictions, consideration will need to be given to whether those other jurisdictions have travel restrictions for their residents. This could be relevant to those in the DMV. And to make matters slightly more complicated, some of the state orders allow local counties or municipalities to impose more restrictive measures. What this means is that in addition to state executive orders, you will need to locate and review local ordinances. This is particularly important if you have offices or locations in different parts of the state. In practice, this means the requirements impacting your operations in one part of the state may differ from another part. Some states also rely on the state or local health agency to supply additional guidance, and in some cases directives, which can include requirements that you must follow. So these will need to be located and reviewed. Once you have located the orders, what are some of the things that you need to be particularly aware of? First, is it a statewide order, or are particular counties or localities not included as they are not yet ready to reopen or in different stages of reentry and therefore under different orders or requirements? You need to look to see whether the state order permits county and municipal order or ordinances that impose more stringent measures, or some of the orders actually outright forbid such local ordinances. You need to look to see whether the latest order preempts or supersedes other orders, or whether portions of earlier executive orders are still in effect. And then you really should focus carefully on the language of the orders. Are the provisions in the orders simply recommended, or are they required? Many state orders include recommendations for some measures and requirements for other measures. And finally, in addition to general business reopening guidance and requirements, some of the states have included industry-specific requirements, which you would need to review as well, if they're relevant. I'm now going to turn it to Todd to discuss some best practices.
Thanks, Chris. So as you can hear from Chris, the most complicated part about this is almost to figure out what rules are going to provide to you so you know how to return. So I look at this almost as what would I do if I ran a business, because even within those rules, there's a lot of flexibility. I've been working with a lot of different jurisdictions. DC just came out, the mayor came out with a new order yesterday. We look at that. Our law firm is based in DC. We try to determine, well, what does that order mean? And even between a number of lawyers, it didn't really seem to move the needle when we looked at it in terms of what she's allowing to happen next, which told us something, which is it's going to be a very slow roll, which is generally how it's working. I'm currently in New York. They have a whole other set of requirements that they've put in place. The other extreme, I was in Texas, or giving a webinar in Texas, and the concerns that were confronting the government contractors and other employers, that they were very different because they were being forced to sort of open quickly and figure out how they were going to do that. So it's mostly a question, as you're going to view best practices, it's staging. It's thinking about what am I going to do over time. It's not flipping a switch. And then it comes down to how you're going to communicate that to employees. And I assume people are already doing that. You're giving people real-time notification, hey, we're not opening this week. In fact, we know we're not going to open for 3 more weeks. The word's not really not open, it's telecommuting. Most businesses have been able to stay open with that. Government contractors have more flexibility because a lot of times the government has required people to continue working, and I'll talk about that in a moment. But the point is, this phased approach, how you're going to, come up with a plan is the first part of doing anything. Can people work remotely? I'm the general counsel of the law firm. I've probably spent 20 or 30 hours just trying over the last few months, even before we knew this thing was coming, of how we were going to come up with a plan. Once you do that, you have to tell your employees. And a lot of that plan is going to be putting forth safety requirements and telling people, this is what you need to do. And you have to be very certain that people actually follow that, because this is what you're going to do is how you keep people safe. And if you don't follow through on that, if you allow employees to get away with it, it's no different than if you were allow someone to get away with violating your discrimination policy. That's when you're going to end up with liability, a negligence claim in all likelihood. So having a written plan so everybody understands what the expectations are and enforcing that is one key. You're going to have certain people at that point who are going to tell you, I'm not ready to come back. Maybe it's anxiety, maybe it's because I'm 65 years old or I'm taking care of my mom who's 95. You're going to have a policy that's consistent, as Posey said, with the ADA and the other statutes, the FFCRA that might apply. So your HR team has to be on its toes and ready to sort of take those as they come. My general viewpoint is that you can push people to come back to some degree. That doesn't mean you have to, but know what the law requires. Decide that you're going to handle it like you would any other request for an accommodation. Some people have been questioning, should I get a release from my employees to actually reduce liability? I don't think that really works, but we've done them. I mean, and they are helpful, and particularly telling people that it's voluntary that you come back initially, or giving people the opportunity to come out and say that it's voluntary if they haven't opted out. That's very helpful. The next key part of it is to just have safety measures in place and training your employees from the moment they walk through the door. Day one, training is very important. Tell people what you expect. Tell people, what areas of the building are going to be cordoned off. Are we not using the lunchroom? Are we making accommodations so that maybe the mail is not brought in around the building? So you're making sure that people understand the protocols for coming back into work and agreeing to that, following safety measures, as I said. That also comes into what are we going to do when there's an infection? What are we going to do with concerns that somebody lives with somebody who has an infection? Again, thinking about all these things. We've had clients who have discussed this with us, for months, in part because it's happened. And again, the government contracting area provides a very interesting set of challenges, because the government can say, as the client, I need you to come. And a lot of people have essential services that they're getting through the government, or they're considered essential employees, which has forced the issue. And, it's not that difficult to deal with. It's just the issue has already been dealt with properly, hopefully. And if not, you have to figure out what, if anything, you do to mitigate any concerns. So I would say training, be prepared. How are you going to do if somebody gets sick? Do you have a process for contact tracing? Our firm is considering some technology I would have never thought existed, where we have a card and you can actually see who comes close to who, and if we ever need it, it'll be helpful. In terms of PPE, I think for the most part, most policies are requiring that you have masks available, so that if you can't social distance within the workplace, that somebody can have a mask, and that would stop the spread. That's, I think, considered best practices. And in every jurisdiction, Texas was not a Wild West kind of situation. They did have policies. So you can require masks, and, you should pay for them, would be my advice. I don't think you have to pay to have them, cleaned, for the employee to clean them. So if we switch to the next slide. Next slide. Hello? Hello?
Hello? Is this the correct slide?
Yeah, I was asking for the next slide.
Is this the correct slide?
It's
Do you need to go back
best
a slide?
practices before reopening.
Is it?
Yeah, unfortunately, my slides are not showing, but it's best practices before reopening.
I think this is it right here.
And it was slide 23. So for that, you have to just look around your offices, decide what you're going to do. Are you going to have a policy where office doors are closed? So developing a risk assessment so that people can understand what it is, developing written plans, as I said. Flexibility, I think, is going to be key. Employees are going to say they don't want to come back. How are you going to deal with that? That's the other thing. And one thing with government contractors is you don't control that environment often when you're working with it. So the question is, you have to understand the procedures and the processes they've put in place, and allowing people, as I said, to opt out, and making sure that the government or the prime has set forth a set of processes. Trying to do the best you can with that is key. And the last slide, if I could. And then after reopening, what I would say here is we have really come up, with materials within our firm, spelling out, sort of what the processes are, how to reopen, what do you need to be concerned about, health screening. It's pretty complicated. We've put together a guide where you really can read, pretty detailed specifics with Q&A that will answer, what do you do if somebody has a diagnosed case, and what's the best way of doing that. So with that, I will turn it over to Tracy.
All right, thanks, Pat. Next slide, please. Yes, so I'm going to talk about some of the unique considerations for government contractors. Todd has mentioned a few of them. Often you are working at a government site and you don't control the space. Number one takeaway is, you should be talking with the contracting officer early and often, both about health and safety issues and contractual administrative issues. Many contractors are not able to work remotely, maybe because they are doing classified work that has to be performed in a secure facility, or they're doing research that has to take place at a lab, or they're performing contracts overseas and maybe they're not able to rotate their personnel because of the international travel restrictions. In most cases, contractors who aren't able to work remotely have been determined to be essential, and so many of them have been working away all the time. So they're not really reopening; they've been working. But one of the issues that we wanted to touch on is, as states are starting to reopen, can the government require contractors to transition back to working on site rather than remotely? I think the first issue would be what does the contract say? Does the contract expressly require on-site performance? If not, then there's both in the statute and in the federal acquisition regulation really encourages contractor teleworking. And so to the extent a customer is asking you to come back on site and it's not expressly required by the contract, I would push back and say, we are supposed to be teleworking to the greatest extent possible. There's no performance-related reason for that, and try to negotiate that out with the contracting officer. The other question is, what rate should you be paid? Often there are different labor rates for working at the contractor site versus the government site because you're not paying the overhead if you're working at the government site. So you want to make sure that wherever you're working from, you're charging the appropriate rate. And if you don't have the appropriate rates in your contract, then maybe you need a modification to reflect the higher rates for working at the contractor site if you have people coming into your offices as opposed to going to the government offices. Next slide, please. So just to echo Posey's point about, in addition to documenting your decision-making process and why you're taking decisions, you want to also be documenting the impacts of COVID and shutdowns and alternative work arrangements on your contract performance. And that can take a variety of forms. It might be that you're unable to access the required facilities. Maybe that there are delays from your suppliers or other contractors because of the travel restrictions. There may be shortages of critical materials. Particularly should be attuned to government-directed changes in how you're doing your work and whether that increases the cost. There may be government personnel who aren't available, and that might delay your performance. So if you need government approval of a deliverable before you can move on to the next thing, or you need inspection and testing of one aspect of a manufactured product before you can continue on, and the government folks aren't there to do that, that's obviously going to delay. You want to document when you made the delivery, when you expected to get the approvals, when you actually got the approvals, and then what effect that had on the overall performance of the contract. It may be that you can get relief for some of these issues, either in the form of additional schedule time or additional payments or both. Read your contract clauses. So there may be a force majeure clause or an excusable delay clause. And those standard clauses say that a pandemic is an excusable delay, so you can't be terminated for delays in your work as a result of the pandemic. That doesn't necessarily mean you're going to get additional payments, but it at least gets you extra time to complete the performance. To the extent that there have been changes directed by the contracting officer, then you may also be able to get additional payment. To the extent that you've actually received a stop work or suspension of work from the contracting officer, there are clauses that govern that process. You could, to the extent that you're unable to mitigate increased costs, you could potentially recover additional costs under those clauses, but certainly you'd be entitled to additional time as a result of the stop work under those clauses. And then finally, some contracts include a requirement that you address if you're deemed essential contractor services. Do you have a plan for how you're going to continue those? And that plan would be incorporated into your contract, and you want to make sure that you're following that and keeping the contracting officer apprised of it. And to the extent that circumstances prohibit you from going through whatever steps that you came up with at the beginning of the contract before there was a pandemic, you want to be alerting to the contracting officer why it is that you're unable to follow the plan that you had agreed upon, and what you're going to do to mitigate that and continue those essential contractor services. With that, I will turn it over for questions.
Thank you to Todd, Christine, Tracy, and Posty for your presentation. It was very informative, and I'm sure the attendees will want the recording and slides, which again we will have posted in a few hours on our website under the COVID contracting section. It will also be emailed to everyone. Now let's look at the questions we received from the audience. There were a few that were sent which were very company specific. Our speakers asked that you email or call them directly using the contact information on the slides. So again, if your question does not appear here today, please contact the good people at Wiley to get answers or schedule a consultation. So we have about 12 total questions. I will read them off now and allow the Wiley team to answer. Our first question is, we have security guards who report to work at remote posts. Some of the CDC recommendations, such as providing personal sanitizer bottles and taking temperatures every time one enters a building, would be very difficult for us to implement. What is the best practice for businesses with geographically dispersed field personnel working on customer facilities?
Well, as we previously mentioned, the CDC guidelines are not requirements as to what an employer has to do. They are recommendations. So some would argue they offer the best practices, but as noted here, for business reasons, they're not always reasonable or foreseeable. So first, the employer in this circumstance would need to check any relevant state or local orders to see if there are any requirements relevant to its workforce, including taking temperatures. And if there are requirements, would need to implement those. If taking temperatures are not required under those orders and it's not feasible for your workforce, an alternative to consider is some type of employee self-assessment or self-monitoring protocol. This can be accomplished through completion of daily self-assessment and or certification forms in which the employee is asked to self-report temperature, other symptoms, or potential exposure events. And this could even be done on an app for ease of completion. Another alternative, which I've heard some employers are considering, is relying on a one-time policy document whereby the employees acknowledge and agree that by reporting to work each day, they are certifying that they have no symptoms. This eliminates the need to track the health and wellness forms, which can be an administrative burden, and it limits the amount of data you are collecting and would potentially need to protect. If you opt for this approach, however, I would caution that it's important to make it clear that it's a term of continued employment and violations can result in termination. And as the pandemic continues, it also would be prudent to send out reminders to the employees that if they violate this policy, they can be terminated. Now, if our employer wants or may be required to take temperatures, but it's not feasible because of the geography issue, you could consider cell phone apps. We've been hearing about those that record temperatures. And moving away from the temperature taking issue, our employer here may want to consider other measures to safeguard its geographically dispersed personnel, including, for example, sending each employee a supply of gloves or masks, hand sanitizer, wipes, or cleaning spray that they can use to wipe down their workstation that they are then required to take to the customer's facility each workday. I also think that this question highlights a couple other issues you should consider. You should also be prepared that your customers may want to know what measures you've taken to safeguard them with respect to your security guards. So you will want to be able to articulate the measures you have taken. And in some cases, your customers may want your personnel to follow their protocol, or in some instances may even provide the sanitizer or masks. Unless anyone has something to add. Next question.
The next question is, as we reopen businesses, are we allowed to test or required to test for COVID-19 for our on-site employees?
So as Chris mentioned, you should be making sure that you're checking local orders to ensure that there is no requirement to test or to check temperatures. But generally speaking, and under federal law, employers are permitted but not required to conduct certain types of health screening measures. That includes taking temperatures or certain types of testing. The EEOC actually recently released guidance that provided that employers may impose mandatory viral testing, but the EEOC has not yet opined that employers are in a position to impose mandatory antibody testing. The question of testing is really one, testing specific to COVID-19 is really one that is interesting because the reality is that tests aren't necessarily readily available and they aren't always reliable based on the information that's in front of us. The other issue is that temperature screenings are much easier to do. Employers can easily implement them, but the issue is that they aren't necessarily reliable indicators of whether or not an individual is experiencing symptoms from COVID-19. That's directly out of the CDC's guidance on these issues. So ultimately, there's some limited utility in these measures, but as we'll discuss a bit later, the issue really comes down to making efforts and putting your best foot forward to take reasonable steps to ensure the safety of your workplace, the safety and health of your employees, and to limit liability. To the extent employers are doing screenings, they should be ensuring that you're training the individuals who will be doing the temperature checks or will be conducting the conversations with employees concerning testing, making sure that they are aware of the things that they can and cannot say, the things that they should and should not say to employees, making sure that they are accurately documenting the information that they get from employees, and making sure that they are also themselves taking adequate safety precautions. Because the reality is that putting an employee out there to conduct, for example, temperature screenings, but not taking the steps to ensure that that employee is protected from potential transmission could subject an employer to liability. We also recommend that employers create appropriate forms to record information and be thoughtful about where that testing would occur. Any information that employers gather, absolutely, including screening results, is going to be protected under the ADA's confidentiality requirements. And that's something that every single employer in the United States is subject to. Those confidentiality requirements mean that you have to keep that information separate and apart from the employee's personnel file. And you also have to maintain the confidentiality of that individual, which we'll discuss a little bit later. The next question.
Question 3. Are positive COVID-19 cases required to be reported and shared with fellow employees and shared with our federal government customer?
And so this question is really a follow-on of the last question, but the short answer here is no. Employers aren't required to report positive cases or COVID-19 exposure, but a key component of achieving the goal of keeping the workplace safe, keeping employees and others healthy, and ensuring that you are timely providing employees and customers with information about potential exposure, is ensuring that you're timely providing employees and individuals that come in contact with those employees with information about their potential exposure to COVID-19. Again, those communications must be guided by careful adherence to the ADA's rules concerning confidentiality, which means that you should not be broadcasting internally or sharing externally the names of individuals who test positive or who have been exposed to COVID-19 unless those people provide their consent in writing. It's also very important when thinking about conducting any type of screening, whether that's a basic questionnaire or more specific screening like temperature checks, to make sure that you're complying with the laws and regulations specific to your jurisdiction. So I mentioned what the ADA requirements are, and those are the same across the board. But there are additional requirements created by the laws in certain states. For example, in California, there is a very strict privacy law that requires you to explain to employees what information you're seeking, why you're seeking the information, and how that information will be used before you seek the information from the employee, and to obtain the employee's consent before soliciting that information. So it's very important to make sure that you're paying attention to the specific jurisdiction that you're operating in, especially for multiple jurisdiction employers. Next question.
I was just going to address the government contracts part of that. Unless there's a specific provision in your contract that requires that disclosure, and I'm having a hard time envisioning what that circumstance would be, you would not have an obligation to inform your customer just because you're a government contractor. Now, maybe you want to, just as a customer relations matter, because your folks are working in a confined space in close quarters with their government colleagues, but you need to be following all of the federal and state rules and statutes that Cozy just went over. Next question.
Question number 4. What information can an employer request from an employee who says he cannot return to work because of a COVID-19 related issue?
So there are a few things to consider here, but I think taking it at a highest level, you'd say, well, what are they really asking for? Are they asking for an accommodation of not coming into work, and how would I handle that normally? And I think the best way to view it is under the ADA, to start there. So how would I deal with a request for an accommodation? What information would I seek? And what information would I seek after the person tells me that they can come back in this instance? So this is one of those situations where you're going to have to set a policy, such as, okay, well, somebody has tested positive. I'm going to wait for them 14 days before they can come back in. Some people have gone, and said, I'm going to have that person tested again. And what happens if you get a false positive? But whatever that policy is, you can ask permission and information, and you can require certain information so that you can make sure that they're capable of returning to the workplace. And at the same time, you're seeking that information so that you could make sure that the other people in your workplace are healthy. The other way this can come up is, what information would you want to have if somebody says, I can't come in because somebody else in my household is sick? And in that situation, again, it's somewhat easy. You can look at the FMLA. You can say, okay, well, that's really what they're asking me. Is it under an FMLA definition a covered activity or covered event such that they are allowed not to come in? The FFCRA expanded that slightly. So again, HR should be able to look at that and decide what is it that I can require, what is it that I need. And I think if you go through that process, the other part of this, though, that's interesting is, some people don't want to return simply because of anxiety and how you're going to deal with that issue. I'm not comfortable coming in because I'm anxious, or I'm not comfortable coming in because I'm dealing with an older employee. older colleague, and they might be getting sick, or my mother's old. All those things, I think, again, you're going to treat as, is there a need for an accommodation? And if not, look, you have to come back. Because I think ultimately you need to be able to control your workplace, and you can be generous to a certain point. But I think that is going to be an issue, and we have seen it, particularly, again, in government contracts, where the government has said, I need people to come back. This is an essential service that we need to have provided. Posey?
I don't have anything to add to that, Todd. I think that's okay. Perfect. I think we can go to the next slide.
Okay, question number 5. In authorizing an employee who has recovered from COVID-19 to return to work, the CDC lists a timed return and a negative test return. What do you recommend an employer use if an employee meets the timed return criteria, but did a test and it comes up positive?
Well, under these circumstances where the employee meets the timed return criteria but has a positive test, I think requiring another test is probably the prudent course. Assuming the availability of tests, the employee probably should wait an additional 7 days from the time of the positive test and then retest. So then I guess we think, what happens if the employee tests positive again? Well, we have all read that there is a percentage of false positives, and as Posey noted, the tests are not necessarily reliable indicators that the person has COVID-19. So are you left to never allowing the employee to come back? I think it really is a question of what is reasonable and what is prudent. And it's important to remember that the CDC proposals on returning employees back to work after a suspected or positive COVID-19 diagnosis are guidelines. So assuming the employee is not showing symptoms, it would seem reasonable that you would allow the employee back after the positive retest, as you would have followed the CDC guidance on timed returns, not once, but you actually would have followed it twice. Next question.
Can employees refuse to complete job duties due to COVID-19?
The answer to this question depends on the reason for the employee's refusal. If the employee has a disability that places the employee at a greater risk of severe illness if they contract COVID-19, then the employee may be entitled to a reasonable accommodation under the American with Disabilities Act. Employees also cannot be forced to work in unsafe conditions that put them in imminent danger. So what is imminent danger? Imminent danger under the Occupational Safety and Health Act means a danger that could reasonably be expected to cause death or serious bodily harm immediately. It remains to be seen whether or not COVID-19 is considered an imminent danger under the Act. But if you consider if the job duty that the person is refusing required business travel to, say, a hotspot coronavirus country, that may rise to the threshold. But most of the work conditions in the U.S., particularly those outside of the high-risk healthcare facilities, likely would not rise to the threshold. But this may be a situation where the employee is simply anxious, as Todd mentioned earlier, or afraid of returning to work due to the pandemic. And depending on whether the employee has been seen by a doctor for anxiety, this may need to be analyzed for any possible ADA accommodations. Now, unless there's a state or local law to the contrary, employers are otherwise authorized to enforce their policies as they would in any other instance where an employee either fails to appear for a scheduled shift or refuses to perform his or her duties, such as disciplining or reprimanding the employee or even terminating the employee. But practically speaking, you may not want to discipline or terminate an employee who refuses to return to work simply out of fear of the pandemic. Reprimanding or terminating such an employee may have a negative effect on the employer-employee relations and a general morale issue. Now, after speaking with the employee to assess their concerns, an employer may consider exploring alternative working arrangements with the employee, such as flexible or remote work options. Now, where remote work is not an option, employees could be afforded a say, a special administrative paid leave for a period of time, or given the option to use their PTO or take an unpaid non-medical leave from the workplace. But whatever you decide based on your company's philosophical outlook, it's best to develop a clear set of boundaries for this type of situation, as Todd suggested, so that your HR department can apply them. Todd?
Next slide, please.
Hey, can we skip to slide number 36, question 9, because it's 150, and we want to make sure that we get the government contract specific questions answered.
Question 9. Can a government contractor receive compensation for additional safety measures it implements to allow employees to return to work?
The answer here will depend on a few different factors. If the contracting officer directed you to take certain safety measures or implement additional, say, cleaning procedures or something, then you could submit that as a request for equitable adjustment with a direct cost under your contract. If you didn't get that sort of direction from the contracting officer and you're just taking these measures on your own, under a fixed price contract, the government is probably going to say that's your choice to take these measures and we're not going to pay you for it. However, it may be possible to recoup some of those costs as indirect costs as part of your overhead. And you'd want to talk through that with your financial and accounting folks and see how you typically treat those types of costs. And if those typically go into an indirect rate pool that you include in your overhead, then you should be able to do the same for these additional cleaning costs or cost of hand sanitizer or whatever it is that you're providing out to your employees. Next question.
Question 10. What guidance, if any, should employers be providing to subcontractors, particularly for federal government contractors?
So, yeah, this goes hand in hand with the communications that you should be having with the contracting officer, and you should be providing as much guidance as possible back down to your subcontractors as well. And that includes, to the extent that you've had conversations regarding Section 3610 of the CARES Act and potential reimbursement for leave that you've paid, you should be giving that same guidance down to your subcontractors in terms of what documentation they need, what may or may not be allowable, because ultimately you're going to be the one submitting that request for the subcontractor's cost into the government, and you want to make sure that those are well documented and well supported. And similarly, you want to be giving them guidance as to whether remote work is okay, whether they need to be coming in. Whatever guidance you're getting from the contracting officer, you want to clearly convey that back down to the subcontractors. Next question.
All right, the next question should be slide 39, question 12.
Question 12. We have a firm fixed price contract with the government, but several of our contractors were required to report for National Guard duty due to the pandemic. Can we bill the government and continue to pay the contractors if there is no one to fill those vacancies? And can we extend the term of the contract proportional to the period of lost performance?
So I'll take the last part of that first. You likely can extend the term of your contract to make up for the lost period of performance. That should be covered under the excusable delay clause. If you need to document that the reason that you were unable to fill the vacancies and be able to track it back to the pandemic, which is a covered excusable delay, and you should be able to negotiate an extension of performance for that. In terms of whether you can bill, you can't bill the government for work you didn't perform as a general matter. there may be some very specific circumstances where you have a fixed price contract and it's written in such a way that you would get paid regardless of whether people were at work or not. But I think that would be an unusual contract. You would also want to look at, does your contract require a certain number of people to be on site? And if you're not able to fill that, then the government's not going to pay you for the full scope of work if that's not what you were providing and if you're not complying with the contract requirements. So I would say it's unlikely that you're going to be able to bill for work that you didn't perform, but there may be some specific contract terms that would permit that. You'd have to look closely at the terms of your contract. Next question.
All right, the next question is slide 34, question 7.
Question 7, are we liable if an employee contracts COVID-19?
Yeah, I think what this comes down to is almost simple negligence standard. So, I mean, there's two parts of it. Are you complying with whatever requirements there are that have been set? And as we said earlier, there are very few requirements that the government has set. The state governments have set some, so those are where you'd have to focus. But the other big concern is, are you negligent? And the standards that are even guidance could define negligence. So if somebody like the CDC is saying this is the proper approach one should take, and you elect not to take that, the question is going to become, was that negligence? Which is you have a duty to protect, which you have to do with your employees, and you've breached that duty, which has caused harm, and there's some causation between the two. And that really requires, when you look at the breach, what would a reasonable person do in similar circumstances? So, is following the guidance something someone would do? How do you adjust the guidance given your specific situation? And that's, again, very interesting for government contractors, because if the government is saying, no, we need everybody to come in, okay, what would a reasonable person do there? You have to fulfill your obligations to the government. And if somebody is going to be in a skiff and shoulder to shoulder with people, what the requirements are, that's going to change the standards from what you'd expect. So the answer is, could you be liable? Sure. Should you be able to curtail the possibility of liability significantly by following the guidelines that have been described today and you can find in a number of places? I think the answer to that is certainly.
Question number 8.
The next question.
Are we allowed to impose restrictions on employee personal travel or their return to work following personal travel? If so, what restrictions can we implement?
So generally speaking, employers don't have the authority to prohibit employees from engaging in otherwise lawful activities such as personal travel off the clock. Employers can and should ask employees about their personal travel history and future plans for travel given the current COVID-19 pandemic. That's just part of your regimen for ensuring that you are insulating yourself as much as possible from liability and protecting your workplace. The key here is training your human resources and management teams to ensure that the manner in which the questions that they ask and the information they solicit is consistent with business necessity and free from potential issues that could give rise to liability under the various employment discrimination laws that employers are subject to. You can also take the following steps, educating employees about the current risks of travel and explaining to them or directing them to information related to that the CDC puts out related to hot zones. For employees who have traveled to high-risk areas and who may have been exposed as a result, employers should be imposing a mandatory 14-day quarantine requirement consistent with the CDC's guidance. If an employee has traveled to an area that's not identified as a high-risk area, the reality is that there's a lot of gray area here. And so employers should really look to the CDC's risk assessment tool, which is available on the CDC website, to determine the level of risk to the workplace and the appropriate steps to take. Again, this is part of ensuring that you are snapping your decisions to some tangible guidance, and the CDC has provided guidance. So there's going to be instances where you can't really get a neat fit. An employee may have traveled to Florida, which is not necessarily a hot zone right now, and they come back, but they are not symptomatic. You should use the risk assessment, consult with your management team, consult with your outside counsel to determine the appropriate move in those instances.
Question 10, what guidance, if any, should employers be providing to subcontractors, particularly for federal government contractors?
We did question 10 already, so the next question would be 3811. Question 11.
Okay, apologize for that. Question 11, what do we do when there is conflicting guidance in the reopening orders relevant to our company?
Well, the federal guidelines, the CDC and OSHA, you've heard repeatedly today, are not mandatory requirements. So for the most part, it's unclear how the federal guidelines will be used in determining what is the proper standard, what is negligence. Where the mandatory requirements come in would be the state and local orders. So you need to review the language of those orders to determine which jurisdiction's order governs your situation. In particular, you will need to look at the relevant state order to see how it addresses local orders, as that is where the conflict typically arises. And what you will see when you look at them is that some state orders permit county and municipal orders or ordinances that impose more stringent measures. So with respect to those provisions, the local order would prevail. But other states' orders specifically supersede any local orders that conflict or are inconsistent with the policy, directives, or intent of the state order. So in that case, the state order would govern those measures. And still other state orders just specifically forbid any local ordinances that address measures found in the state order. So again, the state order would apply. So you just really have to look carefully at the order and what it is telling you as to how it interacts with other state orders and other local orders. Next question, which may be the last question.
That actually concludes our question.
That was
yes.
the last.
So thank you, speakers, for sharing your time and knowledge with us, and thank you to everyone who joined us. Before this concludes, I just want to remind everyone to register now for our virtual Hot Topics in Government Contracting via the link on the slide. This concludes our presentation. Thank you.